The gavel cracked, sharp as a rifle shot, but it failed to silence the judge's choked laughter. Sweat beaded on 16-year-old Maya's brow, not from fear, but from the effort of maintaining a face of bored neutrality. Her public defender slumped beside her, defeated. "A self-defense plea for a $50 fine," Judge Sterling had wheezed, wiping a tear of mirth. "Young lady, this is the Thurgood Marshall United States Courthouse, not a high school debate club. Pay the fine and let's move on. We don't have time for this theatrical nonsense from the South Bronx." The dismissive wave of his hand felt like a physical slap, but the judge was about to learn that the girl he saw, a nervous, defiant black teenager, was merely a costume. The air in courtroom 3B, in the revered Thurgood Marshall United States Courthouse, was stale, heavy with the weight of unfeeling jurisprudence and old leather. Judge Arthur V. Sterling, a man whose lineage in New York law stretched back to the Civil War, sat high above the room, his mahogany bench acting as an unassailable pulpit. He was 72, pink-faced, and possessed of the kind of self-satisfied bulk that often accompanies 2 decades of unquestioned authority. Maya, seated at the defense table, had deliberately chosen the most unassuming outfit she owned: a faded, oversized college hoodie, one size too big to disguise the expensive tailoring of the trousers she wore underneath, and simple, scuffed black boots. Her hair was pulled back into 2 tight, simple cornrows. In this guise, she was simply Raina Jenkins of the Bronx, charged with a misdemeanor: disorderly conduct and failure to disperse during a public demonstration against a local property developer. The actual penalty was negligible, a small fine and community service. But the principle, for Maya, was everything. Her assigned public defender, Mr. Silas Thorne, was visibly exhausted. He had 47 cases on his docket that week, and Raina's was clearly the least important. He leaned close, smelling faintly of stale coffee in desperation. "Raina, please. He's going to close this. Just say you'll pay the fine. We can appeal the conviction later, but don't antagonize Sterling." Maya kept her gaze fixed on the judge's face, not his eyes. To meet his gaze would be to acknowledge his authority in this flawed jurisdiction, and she wasn't ready to grant that yet. "He questioned my constitutional right to public assembly, Mr. Thorne, and he mischaracterized the definition of failure to disperse as defined in New York v. Johnson, 2008. The prosecutor cited the wrong precedent." Her voice was a low, clear mezzo-soprano, sharp and steady. Sterling, having finished reading a physical newspaper, an anachronistic habit he maintained solely to signal his disinterest in the proceedings, looked up, his pale blue eyes magnified slightly by his reading glasses. He clearly hadn't heard her, but his clerk had. The clerk, a young, nervous woman named Ms. Henderson, leaned forward to whisper the comment. Sterling's reaction was delayed but overwhelming. First came the widening of the eyes, then the twitch at the corner of his mouth, and finally, the loud, gusty expulsion of air that began his laughter. It was a laugh of genuine, unbridled amusement, not at a joke, but at a perceived absurdity. The court reporter stopped typing. The 2 bailiffs exchanged glances. "Did I hear that correctly, Ms. Henderson?" Sterling asked, dabbing his eye with a linen handkerchief. "The defendant, Raina Jenkins, claims the prosecution cited the wrong precedent? Is that what the young lady from, where was it, the South Bronx? Yes. Is that what she just claimed?" "Your Honor, with respect," Thorne interjected, scrambling to his feet. "My client is merely frustrated with the process, and I take full responsibility for the legal arguments." No, Mr. Thorne." Sterling waved him down, his voice still choked with residual humor. "Let the young lady speak. This is pure theater." "Young lady," he addressed Maya, using a tone reserved for addressing a pet that had just performed a mildly amusing, yet ultimately inconvenient trick. "Tell me, dear, What case should the esteemed prosecutor have cited? And please, try to keep the answer to one syllable. A few people in the gallery chuckled nervously, a Pavlovian response to the dominant figure's mood. Maya stood slowly. Her movements were economical, almost academic. She adjusted the heavy hood slightly and smoothed the non-existent wrinkles in her trousers. Her face remained a mask of controlled, simmering contempt. "Your Honor," she began, her voice gaining volume and resonance, cutting cleanly through the courtroom's forced pleasantries. "The relevant precedent for the definition of lawful police order regarding public dispersal is People v. Turchi, decided by the Court of Appeals in 2017. The Johnson case, which the prosecution cited, pertains specifically to the temporal constraints on an officer's reasonable belief of imminent danger, not the nature of the command itself." She paused, letting the clinical language hang in the air. Thorne gripped the edge of the defense table, his face a silent plea of, "Stop it." The prosecutor, a slick 30-something named Mr. Harrison, lowered the papers he was holding, his jaw slackening. Judge Sterling stopped smiling. The blood seemed to drain from his face, leaving the pinkness slightly gray. The laughter was gone, replaced by a cold, searing fury. It wasn't just that she was right. The slight inaccuracy in Harrison's paperwork was a known, minor tactical shortcut. It was that she had used the language of the bench against him, correcting him publicly with the poise of an appellate clerk. "Watch your tone, Ms. Jenkins," Sterling hissed, leaning forward. His voice had dropped from a boom to a menacing whisper. "You are an 18-year-old, or 16-year-old, I frankly don't care, being charged with a minor infraction. You are not a member of the bar. You are not in law school. You have no right to lecture this court on the nuance of case law. I suggest you apologize immediately to Mr. Harrison and the court, or I will consider holding you in contempt." Maya felt the controlled anger finally begin to boil beneath the surface. 18-year-old. He didn't even bother to get her basic facts right. He didn't see a citizen. He saw a demographic. She lowered her voice, making it even calmer, more controlled. "Your Honor, I apologize if my recitation of the relevant state appellate decisions was construed as insolence. I was merely attempting to establish the fundamental jurisdictional limits of the charges being brought against me, as is my right under the 6th and 14th Amendments. I am not 18, by the way. I am 22. The lie was delivered smoothly, a deliberate escalation. Thorne shot her a look of pure panic. Sterling's face turned an ugly, mottled red. 22? Oh, that's even better. A wisecracking college dropout who thinks she's Sandra Day O'Connor because she read a Wikipedia entry. I've heard enough of this juvenile grandstanding. I find you guilty as charged. Fine is $250, payable within 30 days. And as for your attempted legal maneuver, Ms. Jenkins, he pointed a thick finger at her. You are a small, inconsequential cog in a very large, important machine. The machine does not stop for you. You are dismissed. He glared, expecting her to crumble, to argue, or to weep. He expected the usual theatrics he associated with defendants who came before him. Maya just nodded once. The movement was sharp and final. She knew that he was now emotionally invested, his contempt firmly cemented. That was precisely where she needed him to be. As she began to turn, she caught the eye of Ms. Henderson, the clerk, and gave the woman a minuscule, almost imperceptible shake of the head. A silent instruction not to enter the judgment yet. The clerk, bewildered and slightly afraid, froze mid-reach for her keyboard. Maya walked away from the defense table, not towards the exit, but towards the bailiffs who were now opening the gate. She didn't look back at the judge, who was already calling the next, equally minor case. She knew the silence she had left behind wasn't the kind she was aiming for, but it was coming. She just needed one more chapter to set the perfect trap. She knew exactly what she was. Judge Sterling was about to find out too. Judge Arthur V. Sterling did not merely preside, he reigned. His courtroom was his fiefdom, and the Thurgood Marshall United States Courthouse served as the gilded cage of his career. He saw himself as the last bastion of true, rigorous law, a dying breed of judges who valued precedent, order, and social hierarchy above all else. He viewed the vast majority of his docket, particularly cases involving protesters, tenants, or minor offenders, not as complex legal issues, but as administrative clutter brought about by an increasingly entitled and disorderly populace. The young woman, Raina Jenkins, had been a particularly irritating piece of clutter. Her knowledge of Turchi was correct, which was the most galling part. Sterling himself hadn't read the opinion in years, relying on the predictable shortcuts of his clerk and the prosecutors. A defendant, a child from the Bronx, was not supposed to know that much. Her display was, in his mind, the height of disrespect, an attempt to use his own tools against him in a manner he deemed unearned and insolent. After the dismissal of Jenkins, Sterling tried to regain his composure by dealing swiftly and ruthlessly with a complex but dull contract dispute between two mid-sized construction firms. But the memory of her cool, steady voice lingered, an acid taste in his mouth. "Mr. Thorne, you need to rein in your clients," Sterling had muttered to the public defender as Thorne prepared to leave the bar. "That kind of disrespect is unacceptable. If I see that young woman back here, I will not be so lenient on the contempt charge." Thorne, desperate to placate the judge, had merely bowed slightly and hurried out, relieved to escape the volatile environment. Meanwhile, Maya, who was in reality 21, not 16 or 22, had not left the building. She was now sitting in the courthouse library, a vast, echoing chamber 2 floors up, pulling volumes off the shelf with the practiced efficiency of a post-doctoral researcher. She wasn't Raina Jenkins, the high school dropout facing a fine. She was Maya Amara Vance, a Juris Doctor candidate at Georgetown Law, currently deferring her final year to serve a highly specialized and deeply confidential legal fellowship with the Brennan Center for Justice in collaboration with a private investigation firm. Her target was not the property developer, but Judge Sterling himself. She was there to document judicial impropriety, specifically concerning the selective enforcement of local ordinances and procedural rules in cases involving the poor and marginalized. The misdemeanor case had been a pretext, a carefully selected opportunity to get Sterling on record. She was pro-C in all but name, using Thorne purely as a shield and a necessary element of the disguise. Maya opened her laptop, the screen a stark white against the mahogany of the antique library table. She was reviewing the transcript she had been generating in real time, using a specialized voice-to-text program disguised as a note-taking application on her phone. "Sterling, this is the Thurgood Marshall United States Courthouse, not a high school debate club. Pay the fine and let's move on. We don't have time for this theatrical nonsense from the South Bronx." Sterling, a wisecracking college dropout who thinks she's Sandra Day O'Connor because she read a Wikipedia entry. Sterling, the machine does not stop for you. You are dismissed. Maya scrolled through the quotes. They were perfect. They showed bias, prejudice, and a clear dismissal of her legal arguments based on perceived social standing and origin. But she needed more. She needed a procedural error, a true abuse of power that linked directly to the massive case she was actually working on, the reason for her entire operation. That case was the estate of Elias Vance versus Omnicorp Technologies, a decade-long saga involving the fraudulent acquisition of public land and the unjust jailing of a key witness. Elias Vance was not only her late father, but the person Sterling had summarily dismissed years ago in a crucial preliminary injunction hearing, effectively destroying the Vance family's livelihood and contributing to her father's premature death. Maya was adopted, but the name Vance was now her shield and her weapon. She had spent the last 4 years training for this moment. She focused her research on the Avery-Tate principle, a complex set of rules concerning the admissibility of electronic evidence in New York State Supreme Court proceedings. She knew Sterling had a notorious history of misapplying this principle in favor of powerful corporate defendants, often based on flawed technical interpretations that only benefited firms with high-powered defense teams. It was his soft spot, his weakness. Maya looked at the clock. Sterling always took his lunch at 1 p.m. and was notorious for being 15 minutes late returning to the bench. At 2 p.m., he was due to hear a preliminary evidence motion in Garrison v. Allied Waste, a case involving a small business owner fighting a corporate environmental cleanup order. That motion was all about the Avery-Tate principle. She quickly wrote a 3-page affidavit in her legal application, carefully using the full weight of her actual knowledge, not Raina Jenkins's rebellious flair, and signed it Maya Amara Vance, J.D. candidate, deferred, Georgetown Law. She printed 2 copies, placing one in a sealed envelope marked Motion to Reopen and Adjourn, and the other, a copy of the affidavit, in her blazer pocket. She pulled off the oversized hoodie, revealing a crisp white blouse. She changed her scuffed boots for a pair of black, impeccably polished leather pumps from her backpack. She undid her cornrows, letting her thick, styled hair fall freely over her shoulders. She applied a light amount of makeup, transforming her defiant teen look into the sharp, professional polish of a young woman who belonged in the halls of power. Raina Jenkins was gone. Maya Amara Vance was ready to take the field. She checked the time. 1:55 p.m., the judge would be 5 minutes late. She descended the stairs, her confidence building with every step, feeling the weight of the sealed envelope, the trap she had set, in her hand. The silence was coming. The clock in courtroom 3B ticked past 2:05 p.m. The bailiff had already called the room to order twice, anticipating Judge Sterling's return. The atmosphere was palpably different now. The energy was nervous, professional, and entirely focused on the upcoming civil hearing, Garrison v. Allied Waste. Mr. Garrison, a small, weary man, sat anxiously with his 2 attorneys. Across the aisle sat the defense team for Allied Waste, led by Ms. Helena Croft, a renowned litigator whose expensive suit seemed to absorb all the light in the room. When Judge Sterling finally swept in at 2:10 p.m., he was still wearing a slight scowl from his encounter with Raina Jenkins. He slammed his water pitcher down and immediately launched into the day's business without an apology for his lateness. "Counselors, let's be brief," Sterling commanded, his voice impatient. "I've read the motions. Ms. Croft, your team is moving to exclude the plaintiff's core electronic evidence based on a technical failure to produce the original metadata under Avery-Tate. Mr. Garrison's team, you claim the principle is being grossly misapplied." "I confess, Mr. Garrison," I lean toward Ms. Croft. "Avery-Tate is clear." Mr. Garrison's lead attorney, Mr. Davies, stood up, visibly intimidated. "Your Honor, respectfully, the plaintiff submits that Allied Waste is seeking to weaponize a minor procedural lapse to suppress evidence that shows a deliberate environmental violation. The metadata, while not in the exact original format specified, can be verified through contemporaneous, independently authenticated." "I don't care about independent authentication, Mr. Davies," Sterling cut him off sharply, his volume rising. "The principle exists to maintain the integrity of the record. If you can't adhere to the letter of the law, the evidence is unreliable. You know this, it's litigation 101. Croft, your argument rests on the integrity of the rule, yes?" Ms. Croft smiled, a slight, predatory curve of the lip. "Precisely, Your Honor. The rule is the rule, and failure to comply is a failure of proof. This was the moment. Maya, who had been standing silently in the back row near the gallery entrance, walked purposefully down the center aisle. She was still wearing the clothes of Maya Amara Vance, the professional student, but she carried the demeanor of someone who belonged there. She stopped just inside the gate, separating the gallery from the courtroom floor. "Your Honor," she said, her voice clear and strong, cutting through the judicial dialogue like glass. The entire room turned. Sterling blinked, annoyed by the interruption. He peered over his reading glasses. "Who are you? The court is in session. Bailiff, please escort this woman out. Gallery members are not permitted to address the bench." Maya didn't move. "I apologize, Your Honor. I am moving for an immediate, albeit temporary, injunction against the enforcement of the ruling in People v. Jenkins, and a motion to reopen proceedings for the purposes of entering a judicial ethics complaint into the record, pursuant to Rule 104D of the New York State Judicial Conduct Code." The room went completely silent this time. An injunction on a misdemeanor? A judicial ethics complaint? Judge Sterling recognized her immediately, despite the change in her clothes and hair. The realization that she was still in the building, that she had changed her appearance to appear more respectable, only doubled his fury and confirmed his initial assessment that she was an insolent, melodramatic student. "Jenkins," he spat, his face flushing crimson again. "I told you, you are dismissed. You are in contempt of court. Bailiff, detain her. Now." As the bailiff approached, Maya stood her ground, holding up the sealed envelope. "Before the court takes any further action, I must state my full and legal name, as the identity used previously was incomplete for the purpose of formal filing. I am not Raina Jenkins. I am Maya Amara Vance. I was here on behalf of the Brennan Center for Justice, under the Professional Observation Program." The name Maya Amara Vance was meaningless to the bailiffs, but Ms. Croft, the lead defense lawyer for Allied Waste, stiffened immediately. She knew the name. The Vance family case was legendary in corporate defense circles, a massive fraud suit that had been destroyed years ago, the family's assets seized, and the surviving daughter now a major annoyance in the academic legal field. Croft was familiar with the rumors. The daughter was brilliant and seeking vengeance. Sterling, however, only heard the first sentence. "You lied to the court about your name and purpose? That is a separate, egregious offense, young lady. You thought you could come in here and play dress-up and file fraudulent motions? This is not a game. I am holding you in contempt. 30 days in lockup." He brought the gavel down, an act of sheer emotional authority. Crack! Maya remained utterly calm, overriding the bailiff who had stopped short, intimidated by the sheer gravity of the moment. She spoke over the echo of the gavel. "Your Honor, I submit that your summary decision to hold me in contempt, based on an alleged lack of credibility in a separate, closed misdemeanor case, while simultaneously attempting to rule on the pending Garrison v. Allied Waste motion, constitutes a clear violation of Rule 103b-6 of the Conduct Code, which mandates impartiality and diligence." She stepped closer to the bench, her eyes meeting his for the first time. "And I have reason to believe, Your Honor, that your ruling in Garrison will be demonstrably biased due to your documented history of misapplying the Avery-Tate principle in favor of corporate defense firms, specifically in the estate of Vance v. Omnicorp preliminary injunction, where your own notes and correspondence, now under subpoena, reveal ex parte communication with Omnicorp's counsel." Sterling's blood ran cold. Ex parte communication. He remembered the Vance case, a small nuisance he had brushed aside a decade ago for a lucrative corporate client who had been his friend. He had destroyed the electronic evidence for them. "Where did you get that information?" That is privileged, Sterling stammered, his composure finally shattering. His face was now a sickly white, the arrogant bulk of his body seeming to shrink under the weight of her accusation. It is only privileged, Your Honor, Maya replied, her voice ringing with finality, until it becomes evidence in a federal investigation, and now I must perform my true duty. She turned to the clerk, Ms. Henderson, who was staring at her with wide eyes. Ms. Henderson, on your official desk, you have a sealed envelope addressed to Judge Sterling. It is marked personal and confidential. Please retrieve it and confirm the filing. The clerk, automatically obeying the formality of the request, even against the direct instruction of the judge, picked up the envelope. Her hand shook as she read the letterhead on the envelope's corner. It wasn't the Brennan Center. The filing, Your Honor, Ms. Henderson whispered, her eyes wide with shock. The letterhead says, The Office of Judicial Review, Court of Appeals, Second Circuit, and the title on the document is Notice of Immediate Suspension and Subpoena Ducis Tecum. The judge, the prosecutor, the defense team, and the entire gallery fell into a perfect, absolute silence. The only sound was the faint hum of the fluorescent lights high above them. The laughter was a distant, forgotten memory. The silence was the deepest Maya had ever experienced. It wasn't the respectful silence of a deliberative court. It was the petrified stillness of a space that had just experienced a total collapse of authority. Ms. Croft, the high-powered corporate attorney, was the first to move, pulling out her phone and furiously texting, her composure momentarily lost. Mr. Davies, Garrison's attorney, looked between the judge and Maya as if witnessing a miracle. Judge Sterling, frozen in his chair, tried desperately to regain control, his hand gripping the edge of the bench so tightly his knuckles were white. "That is a forgery," he roared, but the sound was hollow, laced with panic. "That envelope is not valid. I demand to see the sender's seal. Ms. Henderson, do not open that. I forbid it." Maya, now fully in the role of Maya Amara Vance, took a measured step back, ensuring she was not physically intimidating the judge, but rather formally presenting her position. "Your Honor, with respect, the clerk has correctly identified the source. The envelope contains two documents. First, an official notice of immediate suspension issued by the Second Circuit Court of Appeals, pending investigation into alleged ethical and statutory violations related to your conduct on the bench over the past decade." She paused, letting the word suspension sink into the hearts of the room's attendees. The second document is a subpoena ducis tecum, which is being served on you personally and on the court's records division, demanding the immediate production of all correspondence, transcripts, and financial records pertaining to 3 specific cases. The third of those cases, Your Honor, is the estate of Elias Vance versus Omnicorp Technologies, the preliminary injunction you dismissed on October 14, 2015. She then delivered the final, crushing blow. And as to my purpose here today, Your Honor, the Brennan Center for Justice, in partnership with my family's foundation, has been monitoring judicial conduct regarding the Avery Tate principle. My attendance today, under the alias Raina Jenkins, was not to engage in juvenile grandstanding, but to establish a real-time record of your discriminatory judicial temperament, which has now been submitted as Exhibit A in the Second Circuit's Ethics Review. The full transcript of your comments, specifically theatrical nonsense from the South Bronx, and your description of me as a college dropout who is an inconsequential cog in a machine, is already filed. Maya reached into the pocket of her professional trousers and pulled out a small, heavy piece of plastic, an official identification badge. She held it up for the room to see. My actual capacity today, Your Honor, is not as a JD candidate. I am serving as an officer of the court, specifically designated by Chief Justice Randall A. Peterson of the Second Circuit, to ensure the unadulterated service of these documents. And for the record, The Chief Justice is aware of my identity and my previous legal matter. He finds that my family's direct history with one of the subpoenaed cases makes me uniquely qualified for this task." The air was electric. Judge Sterling looked like a man who had been struck by lightning. He slumped back in his chair, his eyes fixed on the seal on the envelope the clerk still held. The name, Peterson. Randall Peterson. That name was a death sentence in the legal community. Peterson hated Sterling's brand of old guard corruption with a cold, political passion. You are Randall's girl?" Sterling whispered, the volume barely reaching the prosecutor's table. "That old case." "It was your father?" "My adoptive father, yes," Maya confirmed, her voice softening slightly, though her professional demeanor remained steel-hard. "The case you dismissed, allowing Omnicorp to seize public land for pennies and ultimately resulting in the wrongful conviction of Mr. Samuel T. Evans, my father's business partner. That ruling, based on your selective application of the Avery Tate principle, cost lives and futures. And today, your arrogance on a $50 fine just cost you your seat." The bailiff, a veteran of 20 years, slowly walked up to the judge's bench. He was no longer looking at Maya. He was looking at the envelope. He finally took the sealed document gently from Ms. Henderson's trembling hand. He didn't pass it to the judge. Instead, following the internal protocol for receiving documents from a higher court, he laid it squarely in the middle of the judge's desk, ensuring the seal remained unbroken and visible. "Judge Sterling," the bailiff said, his voice surprisingly gentle. "Sir, by internal security code, once a document from the circuit court is formally served with that seal, all proceedings must be immediately suspended. I need to secure the court records and your chambers, sir." Sterling looked at the envelope, then at the bailiff, then at Ms. Croft, who was now frantically gathering her papers and signaling her co-counsel to pack up. The courtroom was no longer his. The machine had not stopped for the inconsequential cog, but the cog had thrown a wrench into the main gears. Maya watched as the judge's world evaporated around him. She had calculated the precise moment, the exact legal phrase that would trigger the protocol, and the perfect humiliation that would ensure the evidence of his bias was undeniable. "Ms. Vance," Mr. Davies, the attorney for Garrison, said, standing up with a newfound vigor, "does this suspension mean that the preliminary ruling regarding the Avery Tate principle has been nullified?" Maya gave him a professional nod. "The entire docket is now under administrative review, sir. You should refile all your motions tomorrow, starting with a motion for recusal, which will be accepted automatically." She turned and walked toward the exit, passing the now frozen bailiffs. Her heart was pounding, but her face was serene. The silence had been achieved. Now came the hard part, the unraveling of Judge Sterling's legacy. The aftermath of Maya Vance's appearance was swift and brutal. Within 30 minutes, 2 high-ranking judicial marshals had arrived from the Second Circuit offices to physically escort Judge Sterling from the courthouse. His chambers were sealed, his personal computer seized, and his entire docket was reassigned to a temporary emergency panel. The news broke initially as a rumor among courthouse staff, then exploded into a local legal scandal by nightfall. Maya, having completed her immediate duty, was now in the heavily secured offices of the Brennan Center downtown, debriefing with her supervising counsel, Ms. Eleanor Shaw. Shaw, a sharp older woman who had initially been skeptical of Maya's aggressive strategy, was now beaming. "The recording is flawless, Maya. Your Raina Jenkins persona was a masterstroke," Shaw admitted, sipping her tea. The combination of the blatant constitutional argument followed by the feigned age confusion and Sterling's subsequent tirade, it paints a picture of textbook judicial bias based on demographic profiling. Randall Peterson is going to use this transcript to set the tone for the entire investigation. It was his use of the word inconsequential, Maya said, leaning back, the adrenaline finally starting to ebb. That was the trigger. He wasn't just dismissing me. He was dismissing the entire legal identity of people like me. He believed he was immune. He thought he was immune because he was immune, until you showed up, Shaw corrected. But let's get to the core of this, the subpoena ducis tecum. We need those files from Estate of Vance versus Omnicorp Technologies. That's where the true karma lives. Maya stood up and walked to a corkboard covered with yellowing newspaper clippings and handwritten notes. My father, Elias Vance, was fighting Omnicorp's attempt to condemn land, a section of the Bronx waterfront, based on a flawed environmental impact report. The report was produced by a shell company Omnicorp owned. During the preliminary injunction hearing, my father introduced electronic evidence, internal emails proving the shell company was a sham and the report was fabricated. She pointed to a clipping from a decade ago. Judge Sterling rules against Vance in preliminary injunction. Sterling ruled the emails inadmissible under the Avery Tate principle. He claimed my father's legal team failed to provide the original, unaltered metadata chain of custody in the exact proprietary format required by Omnicorp's expert witness. It was a technicality only designed to benefit the party with the most expensive IT team. That ruling killed the case. Omnicorp seized the land. My father died a few years later, heartbroken, and his business partner, Mr. Evans, was framed and jailed for allegedly tampering with the documents, the very documents Sterling had already ruled inadmissible. We've suspected Sterling received an improper payment, but we could never prove the ex parte communication, Shaw mused, tapping her pen. The truth is in the technical details, Maya stated firmly. Sterling's standard practice was always to issue a one-line dismissal in Avery Tate cases, citing a lack of compliance. But in the Vance case, he wrote a 4-page memorandum detailing why the format was flawed. I've cross-referenced those technical errors with a subsequent decision by Sterling in a completely unrelated case, Harkins v. City of Newburgh, where he explicitly allowed similarly formatted evidence because the plaintiff was a wealthy commercial real estate firm. His reasoning directly contradicts itself. Shaw looked impressed. The suspension allows the circuit court access to his personal judicial server and his archived emails. We will find the communication there. The technical contradiction is the legal smoking gun, but the ex parte note is the ethical execution. Maya walked over to a window, looking out over the city. She thought about the man Sterling had seen earlier, the teenager in the hoodie. The fearlessness of Raina Jenkins was a carefully constructed fiction, but the fire inside was real. She had learned early that true justice wasn't found in passion alone, but in precision. Sterling had mocked her intelligence, her background, and her right to be heard. Now she was going to use that intelligence to dismantle his entire career. Later that evening, Maya received a text message from Mr. Harrison, the prosecutor from the morning's hearing. Harrison. Ms. Vance, I owe you an apology. Your point on Turchi was absolutely correct, and I also owe Mr. Thorne and Raina Jenkins an apology. If I may, I'd like to talk to you about the Garrison case tomorrow. I think Allied Waste needs a closer look. Even the system's foot soldiers were beginning to shift alignment. The silence in the courtroom had been loud enough to shake the foundations of the courthouse. The machinery of justice, which Sterling believed he commanded, was starting to grind in a new direction. One dictated by the inconsequential cog he had tried to crush. The true drama, however, was about to unfold behind the scenes, where the subpoenaed records lay waiting. The investigation into Judge Arthur V. Sterling unfolded with the grim inevitability of a collapsing structure. The full weight of the Second Circuit Court of Appeals, fueled by Chief Justice Peterson's personal commitment to cleaning up judicial corruption, bore down on the case. Within a week, the subpoenaed records had been analyzed. As Maya and Ms. Shaw had correctly predicted, The key to Sterling's undoing was not a massive, overt bribery scheme, but rather a long-standing, quiet, quid pro quo relationship centered on his unique expertise in the technicalities of the Avery Tate principle. The judicial server revealed a series of encrypted email threads between Judge Sterling and the chief counsel for Omnicorp Technologies, dating back to 2015. The communications, disguised using internal law firm jargon about document preparation best practices, clearly showed that Omnicorp had guided Sterling on the exact technical grounds he should use to exclude the Vance family's electronic evidence. One email, dated a day before the 2015 ruling, was particularly damning. It read, "From Omnicorp Counsel to A.V. Sterling. Subject, next steps on the Vance preliminary. Arthur, please ensure the memorandum is specific about the file header metadata. We need the ruling to reflect a failure of chain of custody at the bitstream level, not merely an issue of file format. This specificity will ensure the evidence is permanently barred from refiling and give us the grounds to argue obstruction later against the partner, Evans. The firm has already made the necessary contribution to your annual Georgetown Law Scholarship Fund." Maya read the transcript of this email in Shaw's office, the final piece of the puzzle clicking into place. "The Georgetown Law Scholarship Fund," Maya said quietly, a bitter smile touching her lips. "That's how they laundered it. It wasn't a direct bribe. It was a donation made to a fund he controlled at his alma mater. A nice, legalistic way to sell a ruling." Shaw nodded grimly. "And you, Maya Amara Vance, Georgetown Law J.D. candidate, were monitoring the man who took a payoff to ruin your family's life, using your own school's mechanism as the conduit. The irony is staggering." The deeper dive into the court transcripts of the Elias Vance case also confirmed the second layer of Sterling's corruption: the prosecution of Samuel Evans, her father's partner. After Sterling ruled the evidence inadmissible due to metadata tampering, the district attorney's office, pressured by Omnicorp's political influence, used that same ruling to charge Mr. Evans with obstruction of justice and fabricating evidence. Evans had been sent to federal prison for 3 years. Maya immediately contacted the legal team working on Evans's appeal. She provided the newly subpoenaed email exchange, proving that the evidence against Evans was created by the very judge who convicted him. "This is immediate grounds for appeal and exoneration," the lead defense attorney for Evans declared over a conference call. "Sterling's ruling was not just flawed, it was malicious. He manufactured the legal premise for a wrongful conviction. We can file the habeas corpus petition tomorrow." The sheer scale of Judge Sterling's casual abuse of power was now clear. His laughter at Raina Jenkins had been a microcosm of his entire judicial philosophy. Law was a tool of the elite, and anyone who challenged that, especially a young, poor black person, was to be immediately and contemptuously dismissed. He never anticipated that the black teen he laughed at would possess the precise legal education and personal motivation to uncover a decade of his corruption. The political fallout was immense. The governor's office issued a statement expressing shock and deep concern. The New York Bar Association initiated disbarment proceedings. The Georgetown Law School distanced itself from the scholarship fund, pending a full internal audit. Judge Sterling, meanwhile, refused to cooperate. When federal investigators finally interviewed him, he remained defiant, insisting his rulings were legally sound and that the email communication was merely professional consultation about complex technical rules. "I simply applied the Avery Tate principle as written," he argued, his voice hoarse. "That child, that Vance girl, she is on a vendetta. She falsified the identity. She ambushed me. Her Raina Jenkins Act proves her intent was malicious." The investigators only smiled, pointing to the transcript Maya had filed. "Your Honor, your defense hinges on the claim that you were unjustly targeted. But what did the court hear you say to Ms. Jenkins when she correctly cited the Turchi precedent? You called her a wisecracking college dropout who thinks she's Sandra Day O'Connor, and told her she was an inconsequential cog. That, sir, is not the language of an impartial judge. That is the evidence of the very bias we are investigating. The investigation pivoted from simple ethical violations to potential obstruction of justice and civil rights violations related to the wrongful conviction of Mr. Evans. The hard karma was hitting in waves, not just the loss of his job, but the systematic obliteration of his reputation and the potential for criminal indictment. Sterling's entire legacy, the one he had protected with such arrogance, was now being written by the person he had belittled. Maya Vance was not just seeking justice for herself. She was serving it to the machine he thought was invincible. 3 weeks after the dramatic courtroom suspension, the hard karma on Judge Arthur V. Sterling had reached its inevitable climax. He wasn't merely suspended, he was formally removed from the federal bench, his judicial pension frozen, and he was now facing charges of obstruction of justice and contributing to the wrongful conviction of Samuel T. Evans. His name, once synonymous with high WASP legal aristocracy, was now a byword for systemic abuse of power. The news cycle was dominated by the saga. Judge Sterling's fall, the teenager who took him down. Maya, as Maya Amara Vance, gave one carefully worded press conference alongside Mr. Evans's legal team, detailing the technical manipulation of the Avery Tate principle and Sterling's documented bias. She deliberately used the image of Raina Jenkins as a symbol of the ordinary citizens whose legal rights Sterling had cavalierly dismissed. Judge Sterling looked at a young black woman from the Bronx and saw someone he could afford to laugh at, Maya stated into a microphone, her voice steady and powerful. He never stopped to consider that the tools he used to protect the powerful, the complex statutes, the procedural rules, could be used just as effectively against him by the very people he deemed inconsequential. Justice demands diligence and impartiality, not arrogance. Mr. Evans was exonerated and released. The state of New York initiated a massive civil review of all cases Sterling had presided over involving the Avery Tate principle, potentially opening the door for dozens of new appeals and exposing a web of legal malpractice that extended far beyond one judge. Maya was back in her final year at Georgetown Law, but her life had fundamentally changed. She was no longer just a brilliant student. She was a recognized legal warrior. She accepted an offer from the Brennan Center to serve as a full-time salaried fellow upon graduation, tasked specifically with creating a systemic judicial review program. One rainy afternoon, Maya found herself standing in front of the Thurgood Marshall United States Courthouse again. She wasn't wearing a hoodie or a crisp blazer. She was simply dressed, holding a simple bouquet of flowers. She walked past courtroom 3B, now sealed with a chain and a notice from the Second Circuit. She walked to the small public library nearby and found the current issue of the New York Law Review on display. The lead article was written by a new author, The Avery Tate Principle. An Instrument of Justice, Not Oppression, by Maya Amara Vance, J.D. She looked at her name, then at the courthouse. She had done it. She had turned an act of casual malice into an engine for genuine change. Later that week, she heard the final piece of Sterling's karma. He had attempted to sell his multi-million-dollar ancestral home to cover his mounting legal debts and potential restitution to Mr. Evans. The buyer had pulled out. The reason? The property was part of the original land deal that Omnicorp Technologies had defrauded the public out of a decade ago. The very deal Sterling had enabled. The land deal was now in litigation again, facing reversal, and the title was clouded by Maya's foundation's legal intervention. Sterling had been hoisted by his own petard, the fruits of his corruption now poisoned by the law he had bent. She smiled, a genuine, quiet smile this time. The machine hadn't stopped, but it had been recalibrated. The fall of Judge Sterling served as a stark, indelible lesson. The rule of law is not a shield for arrogance, but a system whose integrity rests on humility. Maya Amara Vance, once Raina Jenkins, and dismissed as an inconsequential cog, proved that expertise and moral clarity transcend social standing and age. Her actions ensured that justice was served not just in the courtroom, but on the very land Sterling profited from. The former judge lost everything: his career, his reputation, and the very foundation of his wealth, to the technical and ethical precision of the person he had laughed at. The silence that followed her reveal was not just shock, but the sound of an antiquated order finally breaking under the weight of its own contempt.